Hi there, good morning, my dear friends, ladies and gentlemen. This is your friend Dean Joe-Santos Balagtas Bisquera, resuming our uploads on YouTube and dealing with our beautiful concept on Philippine law. And I am very happy to resume these uploads today, October 10, double 10, they call it 2023, which happens to be also my birth month. And so it's a beautiful way of trying to refocus our priority, and I intend to continue to upload a number of slides for your benefit. There will also be another module where my almost 40 years in the corporate management world will be the subject matter of discussion, but that would be in another topic altogether. This session is to take up the suggested answers to Mercantile Law in the September 2023 bar examination. I used to be part of the panel of the Philippine Association of Law Schools and also the UP Law Center that who are invited to develop suggested answers to the bar questions. And so, for some reason, I have not heard from any of them now. I'm not sure that they continue the project. But be that as it may, I am continuing with that mission of uploading my suggested answers to the bar examination on the premise that we could have been invited to give that particular comment. I recall, when I was about to upload, two of my old friends that I have not seen for quite a while. We were very active in the grade school Family and Faculty Association of the College of the Holy Spirit in Mindiola in the 60s. 40 when our 40 years ago, when our children who are now about 50, a little over 50, were still grade schoolers. That's how we met, and I'm referring to Attorney Antonio Tony Viray, retired Vice President for Metrobank, and before that, Executive Vice President of PS Bank before the merger. He is also a Thomasian, finishes law at the UST College of Law, or Faculty of Civil Law, they call it. The other one is an outstanding professor in architecture at the same school, another Thomasian, Professor Antonio Acosta. And they were presidents of the Graspaco before I finally assumed the position also, and made a lot of very memorable moments for us parents. In fact, I'd like to make mention that I had lost touch with a high school classmate at the UST Education High. He moved to another school on our second year. He is Ricardo Cruz, the late Ricardo Cruz, who used to be working as a key man in Quezon City. I was surprised when we were gathering the parents in Holy Spirit. He approached me, and while we probably grew a little bulkier and taller since we were at UST Education High, both of us recognized each other, and I embraced him and said, "Brad, it's good to see you again in a different environment where we are no longer the teenagers that we used to be. Ito, fathers na tayo ngayon at magtulong-tulong tayo to make the life of our daughters fruitful here in the College of the Holy Spirit." Nakakapanginayang kasi Holy Spirit, I understand, is already closed shop in Mendiola, and it must have been very tough financially for them to survive. But the point of the matter is that school has a lot of history in its own credit. You know, nakakalungkot, nakakaawa. And I remember at that time, the president was Sister Pilar, and the principals at the grade school, including the teachers, were very kind, very accommodating. And I would like to make mention that among the supposed to be uh, what we call these mga kolehiyala type of schools, Holy Spirit never assumed the classy type of positioning that it deserved. It maintained a very reasonable tuition fee. Kaya siguro nagkita-kita kami nung dalawang kaibigan kong Tony tsaka ako, because while we were already in the corporate level, at si Professor Antonio Costa was also a senior faculty member at UST, we were still, of course, valuing not only the distance, because we all come from the area of Sampaloc, Santa Mesa, and Holy Spirit was the best school for girls at that time. But Holy Spirit maintained its low tuition fee for our children until the time that the College of the Holy Spirit in Quezon City was opened. Tony Viraya moved to Quezon City, BF Quezon City, precisely because of that. And his children, I understand, continued their high school at College of the Holy Spirit in Quezon City. So this is also a beautiful reminiscing exercise for the College of the Holy Spirit. I salute and greet all the parents of our children in grade school in the 60s. And I hope you remember that we were having fun together. I was the president who changed the entire scenario by bringing in all the mothers and the fathers to become a cheering squad, groups competing kasama ng mga anak. And we had a very good scoring na if the child attends, 1 point in favor of her section. Pag umattend yung mother, 3 points for her and her section. Pero pinakamabigat, because we all already are aware, yung mga tatay, hindi pumupunta yan. So, pang nanay lang daw yan. So, we encourage our daughters to bring their fathers, and they will get 5 points for the fathers. And I can recall that our experience is that the fathers started coming in, initially mga 30-40%. But there was a time that we were hitting about 70 to 80% of the fathers attending and participating, in the cheering contest. Nakakatuwa. No, ako I'm very, very happy to remember those days. And I will somehow bring it with me up to the last moment of my existence here on Earth. That activity where we brought the parents. In fact, mayroon ako na-discovery doon. Yung palang nanay at tatay, hiwalay. And the daughter is living with the mother. Pero seldom do they get together as a family. Hindi nag-uusap yung tatay at nanay. Pero nakakahiya, para hindi halata, they would have an agreement to meet at a certain time before the assembly time doon sa labas ng gate ng Holy Spirit. At doon lang sila nagkikita-kita. Wala pa rin imikan yung nanay at tatay. But the games and the cheering contest involve the participation of the mother and father. Yun ang may point system na malaki. Yung mga bata, talaga namang kasali activity nila yun. And how did I get to learn about this? Oh my God. I didn't realize that the father was one of our sales representatives in Smith Klein, SKNF. He was one of the outstanding salesmen there. So, magaling. But one time, I was the director for finance and administration. Dumating yung nanay sa opisina, and I know her, personally, because we meet at the College of the Holy Spirit. She was working with the bank. And then sabi ko, "Oh, kumusta ka kako? Napadalaw ka sa akin." Sabi niya, hindi pa ako abogado noon. Sabi niya, "Mr. JSB, can I talk to you in private?" Ano namang gagawin ko? Akala ko tungkol sa Holy Spirit. Nung pala, may personal problem. Hiwalay sila nung lalaki. At yung lalaki, kung minsan, hindi nakakapagbigay daw ng kanyang share. So, hiningan niyang tulong ako na total sir, I can already mention the at least the nickname, no, si Ed. Kilalang kilala yun doon sa Smith Line. Oh, sorry. Pero sabi niya, baka naman sir, wag na lang kami maghablaan. Pakiusapan nyo naman yung allowance namin regularly. Padala na niya. Although, alam namin may pamilya siya. Those are some of the stories that I can share with you, and I can talk for hours about it, but that is not our mission in this session. Ano lang yan, libangan kumbaga sa kung may advertisement na sumisingit dito. Yan naman ang konting pakonsuelo at advertisement ko sa inyo para you feel that this is not a very formal way of approaching these things. I would like always the discussion of law to be conditioned kasi law is supposed to be part of our daily life. It's like breathing our own fresh air and oxygen every day. Ganon lang law eh. That's why law should be very friendly and should be understandable even by, dedicated dito, hindi sa mga abogado. Definitely, yung lawyers, magagaling na yan, din nila kailangan to. Yung mga law students, maraming nanonood kasi sabi nila din, pag ikaw nagpapaliwanag, nakukuha na namin yung hindi namin maintindihan. And I feel very proud about that, no? And I feel so happy. At meron pa nagte-text sa akin, nagpapadala ng messages, mga taga taga North Luzon, yung iba pinakamatindi, taga Bicol, taga Samar, Leyte, Western Visayas. Pero pinakamatindi, Mindanao, my God, Butuan, Zamboanga, Davao, Cagayan de Oro. Matindi ang effect sa akin. Biro mo yung isa, hindi lang isa, mga 4, 5. Din, kami very poor. Sabi niya, walang-wala kami. Ang hawak-hawak lang namin dito, yung mga notebooks namin when we were attending our law classes. Yung mga Xerox copy ng mga libro na hindi na halos mabasa. Pero ang pag-asa lang namin na pumasa, manood sa yung mga slides. At din, pakibati mo nga ako, congratulations, pumasa ako sa bar. Member na ako ng Philippine Bar. Oh my God, kung alam lang nila na gusto ko maiyak. Dahil pinaghihirapan ko itong mga uploads na ito. And when there are very poor people who become lawyers, simply because may mga nasabi ako dito, may naikwento ako sa slide ko, lumabas pala sa bar, natandaan nila, yun lang ang alam halos nila. Now they are members of the Philippine Bar, mga attorneys na sila. Okay na yun. And I always tell the Lord, maraming salamat kasi hindi naman ako dapat naging abogado eh. 40 years old na ako nung binigyan mo ako ng chance na mag-aral ng law. Eto, matanda na tayo, just a few days, hindi man days, huwag naman days. Just a few more years, we'll say goodbye to this world. Pero naging abogado pa rin at yun nakakatulong sa mga taong gusto maging abogado. So there's this spirit. Pasensya na po kayo if I become a little sentimental and emotional about this. Yun lang po siguro weakness ko bilang isang participant dito sa YouTube. I always talk to you as if you are in front of me and you are my personal friend. Tuloy na natin to. Baka humaba yung iyak ko eh. So, here is how the mercantile law subject in the 2023 bar came out. Well, I would like to congratulate Justice Fernando because he live up to the commitment na itong bar examination, pag sinabing 20 Roman numerals, matagal ko na nire-reklamo sa Supreme Court. Kasi dati pag sinabi nilang 20 items, 20 items nga, pagkatapos na, let's say, number 1, magkakaroon ng A, B, C question or sub number 1, 2, 3. Before you know it, sa Mercantile Law, nag-average sa mga unang panahon, mga 60 questions. And iba-iba yun, hindi pare-pareho. Kaya nga, I'd like to congratulate Justice Fernando for living up to the commitment na 20. So ito ngayon ang lumalabas. Divided into the subjects, sinort ko yung mga subjects and categorize them according to the major subjects that are offered in the bar. So number 1, there were 6 questions in corporation law. And there were 3 questions in banking. The subject matter of negotiable instruments has been excluded. That's a good sign. And then there was only 1 question. I was expecting more questions in common carriers transportation. Isa lang ang binigay, hindi pa mahirap. Sa insurance, which is one of the more difficult, 2 lang ang binigay. Intellectual property, they increase it to 3. And dito sana, ito nakatago na ito is taxation. They already merged taxation with mercantile law and they gave 5. And the questions in taxation were not giveaway questions. They were really tough. And overall, I would like to rate the 2023 bar as in the scale of 10 by way of difficulties, 1 to 10. I would rate this as in the vicinity of 7 or 8. Hindi madali. And if you are a bar taker who was cramming, medyo dihado ka ng konti kasi marami mga pino rito na binigay na kung nagka-cramming kami. So let's start the ball rolling now. The questions have been in the file, no? Dito sa PowerPoint file na to. They are arranged from number 1, 2, 3, 4, 5. But what I did is to sort them out so that when we will discuss the 6 problems that were given in corporation. So sama-sama yung discussion natin corporation, although hindi sila sunod-sunod doon sa barisan. And then pagdating ng banking, there were 3, ganun din. The 3 questions in banking are hiwa-hiwalay na pinagsama-sama natin. So pagpunta natin sa 3 questions sa banking, magkakasama rin sila. So naka-modularize. Same is true. Isa lang naman yung common carrier. Okay. Tapos sa insurance, 2. Ganun, kasama. Intellectual property magkasama. Tapos yung taxation, huling-huli, 5 rin sila magkakasama. So, that is how we will handle this particular discussion. So, to start the ball rolling, corporation. The 6 problems that were given in corporation can be sorted out according to this listing. There was a problem on corporation by Estoppel. Another problem was given on incorporators, juridical versus natural persons. And then there was a question on stock dividends. Very interesting question, hindi madali. And then yung filling out the board of directors kung may nawala, may namatay, nag-resign, is being covered. And then one of the very interesting question is, can a foreign corporation sue before Philippine Courts? And finally, yung huling-huli, napunta ka dyan sa banking corporation, yung huling-huli is nationalized industries. Yung mga under the Constitution, there are certain industries where non-Filipinos cannot participate in nationalized industries. So, dito pumapasok yung tinatawag na grandfather rule. So, very interesting. So, let's start with the first problem in corporation out of 6, corporation by Estoppel. This one, very, very exciting, very interesting, and there is a decision of the Supreme Court. Let's go. On corporation by Estoppel, the problem runs like this. Number 1 problem. It's number 1 problem. And it is under the topic of corporation by Estoppel. the principle of equity, justice, and fairness. The problem reads, Juan, acting as president of Maharlika Car Dealers Incorporated, MCDI, entered into a contract of long-term lease with Antonino over a large commercial property along Pasuntamo Avenue owned by the latter. When Antonino received a better offer for the commercial property, and having learned that MCDI was not formally incorporated with the Securities and Exchange Commission, he sought to have the contract of lease nullified on the ground that it was void for lack of the essential element of consent, since the lessee was not a juridical person with capacity to contract. May Juan, acting on behalf of MCDI, which is in the process of incorporation, legally insist on the enforceability and binding effect of the contract of lease as against Antonino. Explain your answer. Okay. Our answer, yes, one for MCDI can insist on the signed lease contract despite absence of MCDI incorporation. Explanation. The doctrine of corporation by Estoppel is founded on principles of equity to prevent injustice and unfairness. When a non-existent corporation enters into contracts or dealings with third parties, the person who used the non-existent corporation is stopped to deny the latter's legal existence involving such contract or dealing. The doctrine is to protect the dealings with the public. Nothing prevents its application in the reverse. A person who assumes an obligation in favor of a non-existent corporation, having transacted with the latter as if it was duly incorporated, is prevented from denying the existence of the latter to avoid the enforcement of the contract. And this is consistent with Section 21 of the Corporation Code. And the Supreme Court in 2018 decided this principle here under the case of the Missionary Sisters of Our Lady of Fatima versus Amando Alsona. I'd like to explain. I get excited. This is already a complete answer. But because people would go to these problems talking about corporation, they probably will start wondering, ano bang punot dulo nitong issue na ito? Okay, the puno is this particular space here. And you will remember, the fundamental principle is that when a group of people go out to say that we are a corporation and we're dealing with you, you're dealing with suppliers and we're dealing with customers. We buy from suppliers, we sell to our customers. And we are a corporation. Now, in the process of these transactions, there can be certain statics. Now, in this statics, and the corporation is being sued, this particular group of people who are not really incorporated cannot set up the defense na you cannot sue the corporation because it is non-existent. Manigas kayo. O, nagbenta kayo sa amin, supplier kayo, hindi kayo makakasingil kasi wala naman yung korporasyon na yan. Kayo, bumili kayo sa amin. Yung natanggap nyong produkto hindi tama, defective. Hahablan nyo kami ng breach of contract. Wala kayong ihahabla kasi hindi corporation ito Sabi ng Supreme Court, sabi ng ating corporation law, kung kayo, nagbebenta kayo, you're selling or you're buying and selling, as if you were a corporation, you are called a corporation by Estoppel. You own a corporation by Estoppel. When you present yourself being a group of people as a corporation and you started transacting business, You cannot set up the defense na pag hinabla ka dahil may breach of contract doon sa buying mo and selling mo, hindi pwedeng sabihin na hindi ka korporasyon. Pero that is the truth hindi ka korporasyon. So what did the corporation code do? The corporation said that if you are dealing with the third parties representing yourself as a corporation, the individuals who were who were misrepresenting themselves as a corporation will now be personally liable. Silang ihahabla. And the legal presumption is kayo, hindi korporasyon, general partnership kayo. And therefore, individually, lahat kayo will be liable as general partners, meaning whoever you are dealing with and is suing the supposed non-existent corporation can now sue you in your personal capacity so that whatever has to be recovered will cover even your personal assets. Yun ang effect ng pagiging corporation by Estoppel. Now, the problem becomes interesting by reason of the missionary sisters case. Yung mga supplier naman at customer, alam nila na hindi corporation. Nagbenta, for example, itong pseudo or quasi-corporation. Hindi quasi. Talagang corporation by Estoppel. Yung customer ngayon, alam niya hindi corporation. Nung pinapadala siya ng statement of account, sabi niya, hindi kita babayaran. Non-existent ka naman Hindi ka naman rehistrado Sabi ng Supreme Court in the case of missionary sisters. Kung ikaw ang niloloko nitong mga taong ito, we are making them liable as general partners. Pero in the principle of equity, justice, and fairness, kung yun ang ini-impose natin dito sa mga taong ito na misrepresenting themselves as a corporation, hindi rin yun naman pwedeng gamitin yun din the same misrepresentation to unduly take advantage of that situation. Hindi na fair yan, sabi ng Supreme Court. And so, if you are dealing with this non-existent corporation, the contract that you entered into will be deemed to still be valid. And whatever your obligation is, either a customer or a supplier to this corporation by Estoppel, who will be deemed to be general partners, iba lang yan ang sitwasyon. Kayo, hindi kayo apektado noon. Ginagamit yung palusot yun. You will now be bound to follow the contract that you signed. So ito si Antonino, pinaupa niya yung kanyang property. Ay na-discover niya, tapos sila magpirmahan ng contract of lease, may mas mataas pa lang gustong bumili. So sabi niya, ayoko nang i-honor yung kontrata natin, ibibigay ko rin sa isa. And so naghabla ngayon yung korporasyon. And so in this particular case, nangyari is the Supreme Court said, ayun yung hindi corporation yung missionary sisters, sila naghabla. So sabi nila, hindi nyo Mr. Alsona, hindi mo pwede kami lukuhin. The Supreme Court agreed. Hindi, kung meron kayong contract ko, please, committed ka na doon, paupa mo sa kanila yun. Dahil, kasi even if they are not a corporation, they can incorporate it. And so, the incorporation effectively retroacts to the time that they signed the contract of lease when they were not yet a corporation. This is one of the most beautiful concepts that have been introduced and given in the 2023 bar examination. I'd like to congratulate the examiners for giving this particular thing because it highlights now that yung corporation by Estoppel hindi lang pala one-sided. Yun ang intindi natin sila nanloloko, corporation kami, hindi lang pala corporation. Hindi nyo pwede lokohin ng public dahil you will have your liability as general partners kasama ang mga personal assets nyo. Natapos na yon. That's the original concept that we have all learned in law school. With this particular missionary sisters of Our Lady of Fatima versus Amando Alsona case, the Supreme Court further covered the second half by saying hindi mo rin pwedeng gamitin yung fallacy ng corporation by Estoppel na yung obligasyon mo naman na talaga naman dapat obligasyon mo, here the contract of lease, hindi mo natutuparin. Hindi pwede yan. Tuparin mo yan. Okay. Very beautiful. I'd like to congratulate the examiner who gave this. No? I don't know him, but I'd like to congratulate him. After discussing the concept of corporation by Estoppel, pupunta tayo dun sa concept of incorporation. So you have a corporation being organized and you have incorporators. Tingnan natin kung ano sinasabi nitong case na ito. Ililipat ko uli yung aking rito para makita natin because the problem is on the left side of the screen. And the screen says problem number 2. So ito, 1 and 2. Kasunod, puro corporation. Under incorporators, natural versus juridical persons, the problem reads, Datu Commercial Corporation or DCC, a publicly listed company with the Philippine Stock Exchange, incorporated Kidlat Close Corporation, KCC, investing into 91% of its outstanding capital. The chairman, president, and executive vice president of DCC are incorporators of KCC, each holding 3% of the outstanding capital stock. The articles of incorporation of KCC provided 1. A limit on the number of shareholders which shall never exceed 5. Number 2, a right of first refusal. And number 3, a prohibition on the shares from being listed or being publicly offered. Pending the issuance of the Securities and Exchange Commission of the Certificate of Registration, the Vice President of KCC entered into a long-term contract of lease on behalf of KCC, which was declared therein as undergoing incorporation with the SEC. Is DCC qualified to be an incorporator of KCC, although it is a juridical entity? Explain your answer. Okay, so yung sinasabi rito sa opening parang yung number 1 eh. Pero yung tanong, that's why in the bar examination, be very conscious, immediately look at the problem which is at the end. No? So tanong, is DCC qualified to be an incorporator of KCC, although it is a juridical entity? So the question is answerable by yes or no. And the yes or no will depend upon sino ba yung KCC? In this case, if you go to the problem, KCC is another corporation. So in effect, ang question, can a corporation be an incorporator? No? Kung 5 sila, pwede bang ikalima siya? Okay, tingnan natin ang sagot. The answer is yes. DCC as a juridical entity can be KCC's incorporator. The incorporators may be composed of any combination of natural persons, SEC-registered partnerships, SEC-registered domestic corporations or associations, as well as foreign corporations. This is in accordance with Section 3 of the Securities and Exchange Commission Memorandum Circular number 16. And citing now Section 42 of the Revised Corporation Code, it says, the corporation has the power to invest corporate funds in another corporation or business or use corporate funds for activities covered by the Secondary Purpose Clause. This is addressing now the issue on KCC. If KCC is qualified to become an incorporator of DCC, in turn, can DCC do that? In other words, can KCC do that? Kumbaga sa yung DCC, pwede niyang tanggapin yung KCC as an incorporator. Ang tanong, yung KCC ba, pwede siyang mag-invest? And Section 42 is saying, yes, pwede. Okay? So that is how problem number 2 runs. So for those who know the problem, know the principle, your answer is very easy. For those who do not know, my God, you'll get lost. No? Talagang ganun ang buhay. Next, The third question on corporation law has something to do with stock dividends. Tingnan natin. The problem on stock dividends is under the concept of the retained earnings. And this is problem number 3. And then sunod-sunod, 1, 2, 3, 4 corporation. It reads, the Board of Directors of Mabini Corporation, MC, unanimously adopted a resolution directing its management to issue as fully paid 10,000 common shares to Attorney Apolinario for successfully prosecuting in favor of MC the derivative suit filed by a minority stockholder over mismanagement of corporate affairs. If the issuance of the 10,000 common shares in the name of Attorney Apolinario is by way of stock dividends to be credited from the unrestricted retained earnings of MC, would such issuance be valid? Explain your answer. Our answer is no. The issuance of stock dividends to Attorney Apolinario would not be valid. Our explanation. The Board of Directors may declare dividends out of the unrestricted retained earnings, payable in cash, property, or in stock to all stockholders based on the outstanding stock held by them. Stock dividend shall be issued with the approval of stockholders representing at least 2/3 of the outstanding capital stock at a regular or special meeting duly called for the purpose. MC stockholders representing 2/3 of the outstanding capital stock did not approve the declaration of stock dividends after the Board of Directors declaration. Tingnan nyo ha. Kailangan approve ng 2/3 para stock dividend. Approve ng board, tapos papasok sa stockholders, 2/3 dapat boboto, yes, stock dividend. Okay. So ito, walang boto ng 2/3 boto ng stock dividends. After Attorney Apolinario cannot receive MC stock dividends because he is not a stockholder. The stockholders did not approve said stock dividends which are given only to registered stockholders. Ganun kasimple yun. Apolinario, very good ka. Ginawa mo yan. Ito stock dividend. Paano niya matatanggap? Hindi naman siya stockholder. Only incumbent stockholders can receive stock dividends. And before that can be done, 2/3 of the total shareholders should approve the stock dividend. Dalawa kasi dividends. And if you remember, yung cash dividend, pag in-approve yan ng board, hindi na kailangan niya ng board ng stockholders. Bakit? Sila yung tatanggap ng cash eh. Chances, ang probability is they will all approve cash dividends for them. No? Pero yung stock dividend, parang cash na, naging bato pa. Kaya kailangan pumayag sila 2/3. Parang binigyan mo sila ng pera, bibilin din nila yung stock nila. Kailangan papayag mo 2/3 nun. Kasi kung hindi nila approvean yun kung hindi cash dividend. More so here, no? Namimigay ka ng stock dividend, hindi naman stockholder. At just to declare stock dividend, kailangan mo 2/3 vote. So on both cases, no, on the basis of these two circumstances, there is no approval of 2/3 vote by the stockholders to grant stock dividend. And the stock dividends are limited to only existing stockholders, and Attorney Apolinario is not a stockholder. So the answer is no. The issuance stock dividends to Attorney Apolinario would not be valid. The next question under corporation law is the Board of Directors. Tingnan natin kung anong tanong sa Board of Directors. Under the Board of Directors, the subject matter is filling up the Board of Directors. The Articles of Incorporation of Dakila Incorporated provides for 7-member Board of Directors. Florante, the chairperson of the board, resigned barely 2 months into office, while Laura, another director, died in a vehicular accident on her 6 month in office, thereby leaving only 5 members in the board. The 1 year term of office of the remaining directors had just ended without an annual stockholders meeting being held, since Laura was actually the majority stockholder of DI and her estate was still being settled. May the remaining 5 directors acting as the board fill in the vacancies in the board. Explain your answer. Very beautiful question. Our suggested answer, no. The remaining 5 directors cannot fill in the board vacancies. Their term has already expired. They are no longer directors. No? So while they're remaining, they did not remain as directors. Dahil nag-expire na yung kanilang term. Okay? And so therefore, any vacancy occurring in the board of directors of trustees other than by removal or tinanyo by expiration of term may be filled by the vote of at least majority of the remaining directors or trustees, if still constituting a quorum. Otherwise, said vacancies must be filled by the stockholders or members in the regular or special meeting called for that purpose. So the reason why they cannot fill in the position of Florante, the chairperson, who resigned, and Laura, who passed away, and she's the controlling stockholder, sabi rito, no? Laura is the majority stockholder. So dalawa ang wala, very critical, chairman at controlling stockholder. Now, meron bang quorum pa? Theoretically, may quorum kasi 1 vote lang naman ang bawat director of the 7. Okay. So pwede pa magbutahan yung 5. Kung sila, existing director pa. Sabi rito, no, any vacancy occurring in the board of directors, no, other than by expiration of the term. Kung baga hindi pa na-expire yung term ng 5, pwede pa magbotohan, silang boboto kung sino ipapalit dun sa dalawang nawala. Pero expired na yung term nila, therefore they cannot anymore exercise the right to vote as a director. And so what should we do? We should now go and meet the stockholders in a regular meeting or special meeting called for purposes of electing the directors. So mabubuo na naman yung 7, fresh, new set of 7 directors. When the vacancy is due to term expiration, the election shall be held no later than the day of such expiration at a meeting called for that purpose. Yun, pag nag-expire, meeting na, botohan. So walang there is no need for the carry-over concept in positions. And continuing now, ang sabi natin dito, when the vacancy prevents the remaining directors from constituting a quorum, may remaining directors, an emergency action is required to prevent grave, substantial, and irreparable loss or damage to the corporation. The vacancy may be temporarily filled from among the officers of the corporation by unanimous vote of the remaining directors or trustees. So, pwede palang, kung sakali, hindi pa expired yung kanilang term. Pwedeng lagyan. Upon the death of a stockholder, his executor or administrator becomes vested with the legal title to the stocks owned by the deceased stockholder, who should hold them for the benefit of the legal heirs until a settlement and division of the estate of the deceased are effected. So, merong pwedeng pumalit doon sa deceased director. Yung kanya nakalagay dito, administrator or executor. Pending determination of the legal heirs, the executors, administrators, receivers, and other legal representatives duly appointed by the court may attend and vote in behalf of the stockholders or members without need of any written proxy. So this is consistent with Section 28, Title 3 of the Revised Corporation Law, and also SEC Office of the General Counsel Opinion number 6-28 on voting rights of heirs of deceased stockholder. Inabanggit natin kanina. And also here, ang hirap basahin, Berneteg, Umali, Paco, Seso, The second, General Counsel, Securities and Exchange Commission, Department of Finance. Okay. So that is our board of directors. We have two more problems under corporation law. Now we go to the problem on foreign corporation. Ang ganda nung ano natin, no? Merong kurtina na umuusog. Very, very neat. So, problem number 6. Sunod-sunod eh. Foreign corporation capacity to sue. Reading now the problem. Singha Corporation or SC, a corporation organized and existing under Singapore laws, filed a complaint for a sum of money and damages against Muni Corporation, MC, a Philippine incorporated company, before the Regional Trial Court of Manila. SC alleged in its complaint that it was neither doing business nor licensed to do business in the Philippines, and it was suing MC on an isolated transaction involving a contract for design consultation and rowing development. MC allegedly failed to pay the remaining 50% of the contract price despite repeated demands from SC. During trial, SC admitted filing a prior collection suit against another company in the RTC. Hence, MC filed a motion to dismiss the case on the ground that, contrary to its allegation, SC was in fact doing business in the Philippines without a license and thus had no legal capacity to sue. Will the motion of MC prosper? Explain. Our suggested answer is no. MC's motion to dismiss versus Singha's collection case will not prosper. Singha's collection cases in two separate instances did not constitute doing business in the Philippines without a license. Singha has legal capacity to sue before Philippine courts. Collection case, no? Maraming collection case, pero that's not doing business. Okay. So, if a foreign corporation does business in the Philippines without a license, it cannot sue before Philippine courts. So, very critical na is the collection case, no? Dalawa sila. Final sa korte is that doing business. And the position of the Supreme Court in Mentolatum versus Mangalim, a 1941 decision, which Mr. Campos cited in his book on Corporation Code, Volume 2. So, yun. Pagka pala nangungulekta lang kahit na maraming collection, hindi doing business in the Philippines. But if you are judged to be doing business in the Philippines, you cannot sue naman if you did not register yourself for the SEC. And now we go to our number 6 problem in corporation law. Nationalized Industries Grandfather Rule. Natin. Very interesting. Sabi ng isang estudyante ko, Sir, parati mo sinasabi, very, very interesting. Paano lahat yata ng problem na yan, mahal mo eh. O, natutuwa ka sa ano. Yeah, it is to me a very enjoyable mental calisthenics to be facing this particular problem. Okay, now the problem reads, Philippine Corporation, Nationalized Industries. China Telecommunication Company, a Chinese state-owned enterprise, sought to acquire 40% equity in Duon Telecommunications Corporation, DTC, a telecommunications company in the Philippines. When questioned by the two major telecommunications companies in the Philippines, Cheng, the president of DTC, defended the proposed acquisition by saying that CTC is allowed to own 40% equity pursuant to the nationality requirement under the Constitution. Is the argument of Cheng correct? Discuss your answer. So, meron palang Philippine Corporation, doon Telecoms, TTC. Gusto sumali ngayon nitong China Telecommunications, 40% equity. Under that particular thing, kung sakali na ito 40% CTC own na itong DTC, can this be considered a Philippine corporation considering that Duon is engaged in a nationalized industry, telecommunications. Our suggested answer, Cheng is correct. That 40% investment of China Telecommunications CTC will allow Duon Telecommunications to engage in the nationalized telecommunications industry when Duon 60% equity remains with Filipino citizens. Okay. When 60% of Duon capital remains as 60% Filipino-owned, Duon is deemed to be 100%. Yan ha. Pag 60% na yon, automatic yung korporasyon na yon, 100% Filipino under the grandfather rule. It is qualified to engage in the nationalized telecommunications industry. The beneficial ownership shall remain under Filipino control. Under Republic Act 7042 and 1999 enactment amended by RA 8179, an amendment approved in 1996. And the example is lifted from the case of Nara Nickel and Mining versus Redmond Consolidated Mines, and a decision of the Supreme Court that was made in 2015 under GR 1955-80. So yung po ang nationalized industries under the grandfather rule. We have covered the 6 questions on corporation law in the 2023 bar examination in Mercantile Law. So we go back now to our master schedule. Sabi natin, tapos ka na rin sa corporation law. Ang susunod na kapila nito, banking. So, diretso na tayo sa banking. Yan, ang banking natin. Babalik natin muli dito. Kung makita nyo. Bumalik dito sa ano. Mali ang pindot. Kasi dapat, hindi pinipindot ito dahil babalik doon sa first. Dapat pindot lang ito para lumabas yung susunod na modules. So these are the problems under banking. Tatlo sila. And masyado nagmamadali. Dito muna ulit tayo sa central bank. Yeah. Medyo bababa ako ng konti dito para makita nyo. So, under banking, ito yung mga 3 questions. The first question is something to do with the central bank regulation. The second question has to do with secrecy of bank deposits. And the third question is something to do with the Anti-Money Laundering Law. Okay, tignan natin. Ano ba yung question sa central bank regulation? Under central bank regulation, the very critical question runs like this. Number 6 ito. Procopio owns the controlling interest of Ginto Bank. Due to the promising potential of lending with real estate collateral, the bank primarily focused on said transactions. After the Bangko Sentral ng Pilipinas conducted its examination of GB, the bank was placed under receivership due to illiquidity as well as unsafe and unsound banking practices. Procopio contends that the actions of the BSP were arbitrary and denied GB its right to due process. He said that GB should have been given due notice and prior hearing, where the bank could have explained the reasons for its illiquidity. Is the contention of Procopio correct? Explain it. Very interesting. Our suggested answer, Procopius' contention is not correct. The Monetary Board may summarily and without need for prior hearing forbid the institution from doing business in the Philippines when the Monetary Board finds the bank insolvent. Ito may public interest na eh. Insolvent na. Hindi na makabayad. E baka lalo pang umutang ng umutang mabaon. So ititigil na ng central bank operation yung ganyan mga bangko. Hindi na, summary nga immediate. Kasi parang ano yan eh, parang hemorrhaging. Okay. The receiver, PDIC, shall immediately gather and take charge of all the assets and liabilities of the institution, administer the same for the benefit of the creditors, and exercise the general powers of a receiver under the revised rules of court. The receiver shall determine not later than 90 days from the takeover whether the institution may be rehabilitated or placed in such a condition so that it may be permitted to resume business with safety to its depositors and creditors and the general public. The receiver determines that the institution cannot be rehabilitated if the receiver determines that the institution cannot be rehabilitated or permitted to resume business. The Monetary Board shall notify in writing the bank's board of directors of its findings and direct the receiver to proceed with the liquidation of the institution. Bangko Sentral's Monetary Board is a quasi-judicial agency with its decisions, resolutions, and orders. BSP is likewise an administrative agency with powers and or functions characterized as administrative, investigatory, regulatory, quasi-legal, or quasi-judicial, or a mix of these five, as may be conferred by the Constitution or by statute. BSP's Monetary Board exercises quasi-judicial functions whose acts or omissions can only be questioned before the Court of Appeals in a petition for certiorari under Rule 65. And so the subject matter is the new Central Bank Act number RA 7653, 1993, and very sentimental, Bangko Filipino versus Bangko Sentral ng Pilipinas and the Mauricio Council. And you have there the GR date and GR number and the date June 4, 2018. Okay? Bumabalik-balik. Tingnan natin kung babalik ulit. Babalik pa rin. Iwan natin. Nag-stalemate tayo. So, ayun. Bumalik na rin sa main event. So, our second topic under banking is the subject matter of the secrecy of bank deposits. So here, also on banking now, but dealing with the secrecy law. The problem reads, Jacinto, the governor of Sorsogon, maintains United States dollar deposits in various offshore banks at the Cayman Islands, British Virgin Islands, and Switzerland. In an expose by Balita magazine called Pandora Papers, the writer detailed the offshore deposits of Jacinto amounting to US $60 million as well as his other investments and holdings. Agreed, Jacinto filed a criminal complaint against Balita magazine for violation of the bank secrecy laws, alleging that his dollar bank accounts were illegally disclosed even though they were neither involved in any civil or criminal liability against him nor subjected to any investigation by the Anti-Money Laundering Council. Will the complaint of Jacinto prosper? So Jacinto has filed a case of violation of the secrecy law against this particular magazine called Pandora Paper. So let us look at our suggested answer. Our suggested answer is no, Jacinto's complaint will not prosper. The secrecy of bank deposit law is intended to penalize persons connected with the Bangko Sentral ng Pilipinas or with any Philippine bank who discloses the bank balance of any depositor. Balita Magazine is not a bank, so that the discretion on Jacinto's bank accounts is not covered under the restriction of the secrecy law. There is a green patch here. It says law on secrecy of bank deposits and secrecy of foreign currency deposits. Hiwalayin. Both support the confidentiality of bank deposits. The secrecy law is to encourage people to deposit their money in banking institutions and to discourage private holding so that the same may be properly utilized by banks in authorized loans to assist in the economic development of the country. It covers all deposits in the Philippines, and no distinction was made between domestic and foreign deposits. RA 1405 is a law of general application. RA 6426 is to encourage deposits from foreign lenders and investors, a special law for foreign currency deposits. Continuing. The offshore banks at the Cayman Islands, British Virgin Islands, and Switzerland, who could have disclosed Jacinto's bank accounts, are outside of Philippine jurisdiction. So, yung mga under jurisdiction lang, those who are working with the Bangko Sentral or those who are working with Philippine banks. And so, pag nagdadalada sila tungkol sa deposit ng isang tao, violation. Pero ito, kinuwento ng Pandora Papers yun as the report of a media company called Balita Magazine. However, the subject matter of the money that was supposed to be disclosed in the article are monies that are in the offshore banks at Cayman Islands, British Island, and Switzerland. And they were not part of the, of the restriction because they're offshore banks. And they're outside of the Philippines, outside the Philippine jurisdiction. So walang kaso. Okay? So next, ayun, bumalik na naman. Hindi natatamaan yung tamang dapat tamaan. Ayun, tamaan na uli. Bumalik na uli dun sa ating slide on banking. And so the last subject matter under banking is the famous Anti-Money Laundering Law or the AMLA. Here, the problem in the anti-money laundering case reads like this. Attorney Diwa is the lawyer of Tala in a criminal case for estafa before the Regional Trial Court of Manila. After one of their hearings, Tala gave Attorney Diwa 10 million for safekeeping, which Tala admitted in confidence that it was part of the proceeds of her swindling. The husband of Attorney Diwa found out about this and reported it to the Anti-Money Laundering Council. The AMLC demanded Attorney Diwa to disclose the details of her transaction with Tala, but she refused. Can Attorney Diwa already validly refuse to report the transaction with TALA. Discuss your answer. Sorry, merong konting lapses. Medyo merong split second na my brain was working outside of this module. So suggested answer, yes. Attorney Diwa can validly refuse to report a transaction with TALA by virtue of the confidential nature of the lawyer-client relationship. Lawyers and accountants acting as independent legal professionals are not required to report covered and suspicious transactions if the relevant information was obtained in circumstances whether subject to professional secrecy or legal professional privilege. This is contained in Section 9C, an act further strengthening the Anti-Money Laundering Law, amending RA 9160, the Anti-Money Laundering Law of 2001. Okay. So that's how simple the answer is on the anti-money laundering. Hindi pwede kapag ka merong attorney-client relationship, privilege communication. Yeah. So we have completed with a little few seconds medyo naidlip ako ng konti kanina. Pasensya na kayo. Oo. And we have done now 2 corporation and now banking. Babalik na tayo nun sa ating main event. No? What remains for us now would be yung common carrier, insurance, intellectual property, and taxation. Yung taxation ang medyo mahaba. Tingnan natin ng konti itong common carrier. Straight tayo kagad dun sana. Wala tayong interim slide. And the problem on common carrier reads like this. It has something to do with breach of contract of carriage. And this is not something that is easy. Medyo mahirap ito. And I remember this was already given in an earlier bar exam. So reading now, problem number 11 on the bar exam says, Harry and Reyna booked a honeymoon package at Anya Resort, AR in Palawan, which included transportation from Batangas to Palawan and vice versa. Hold on for a moment. And via MB Princesa, owned and operated by AR. Despite pag-asa storm warning bulletins, MB Princesa proceeded to ferry Harry and Reyna from the port of Batangas to Palawan. While in open seas, the boat was hit by big waves and eventually capsized, drowning Harry and Reyna. When sued by the heirs of the couple, AR denied liability on the ground that it is not a common carrier, as MB Princess is not available to the general public or other tourists and exclusively ferries resort guests and crew members. AR further argued that they did not charge Harry and Reyna separate fees to board MB Princesa. Are the arguments of AR correct? Discuss your answer. Our suggested answer is no. Anya Resort's arguments do not disprove that they are common carriers, liable for breach of contract of carriage which brought about the death of Han and Reyna. Anya Resorts is a common carrier who engages in the business of carrying or transporting passengers or goods or boat by land, water, or air for compensation, offering its services to the public. No? So in this case, by water. A common carrier involves carrying persons or cargo as a principal business activity or only as an ancillary activity or sideline. So this is very important to emphasize that even if your transportation services is only a sideline, you will still be considered a common carrier by virtue of the De Guzman case. There is no distinction between a transportation service provider on a regular or scheduled basis and one offering such service on an occasional, episodic, or unscheduled basis. Yun ang ine-emphasize doon sa De Guzman case. The target may be general public, that is the general community or population, or only a narrow segment of the general population. In this case, resort guests and crew members are they supposed to be limited market, but it is still considered a part of the category of general public. Its ferry services are closely linked with its main business as to consider it as an ancillary business. So yung main business nila, yung resort. Pero yung pagdadala ng mga passenger becomes a sideline or ancillary business na almost a necessary feature of their business. And so continuing now, it is the practice of beach resort operators offering their tour packages to include the transportation fee in arriving at the tour package price. Nandun na yun. Any resort is therefore a common carrier with breach of a contract of carriage on the death of Harry and Reyna. And this is under Article 1742 of the Civil Code, covered specifically by the case of spouses Dante Cruz and Leonora Cruz versus Sun Holidays. Ito yung actual case. And then the case of Pedro de Guzman versus C.A. and Ernesto Sendanya. The De Guzman case, which was in 1988. And so that essentially is the singular problem on common carriers given in the 2023 bar examination. Now we're ready to go to the fourth module. There are 6 modules, 1, 2, 3, 4, on insurance. And in insurance, there are 2 very interesting questions. A question on insurable interest and the question on concealment in life insurance, which covers the incontestability loss. Tignan natin yung insurable interest. Problem number 9 in the bar exams is Emilio owns a car which he purchased from Gregorio. Emilio agreed to pay Gregorio the balance of the purchase price in the amount of 500,000 pesos within 1 year. To secure the payment of the balance, Emilio and Gregorio executed a security agreement that complies with the requirements of the Personal Property Security Act. The security interest was also perfected in accordance with the PPSA, who has insurable interest over the car. Actually, there are specific provisions under the Personal Property Security Act. But since the question revolves on insurable interest, the concept of insurable interest has been clarified very clearly in the insurance code. So let's take a look at our suggested answer. Petitioner as a lessee has an insurable interest in the equipment and motor vehicles leased. Yung lessee, yung umuupa, si Gregorio. Section 17 of the Insurance Code provides that the measure of an insurable interest in property is the extent to which the insured might be damnified by loss or injury thereof. It cannot be denied that JBL will be directly damnified in case of loss, damage, or destruction of any of its properties. And so this one is a strange initial answer, but it is relevant. Sabi, Emilio as the owner and Gregorio as the creditor for the car, may balance pa, have insurable interest in the car. Pareho sila, pero hiwalay ang insurable interest nila. That the loss of the car will bring about financial pecuniary loss to each of them. Pag nawala yung car, siyempre yung owner, total exposure siya, nawala siya ng kotse. Pero si Gregorio, may utang to sa kotse. So pag nawala yung kotse, no, nawalan din siya in effect nung binayad na niya na equivalent money. So nawalan din siya. Gregorio is a secured creditor under the Personal Property Security Act. Yan ang question on insurable interest na mistizo under insurance. Okay. The second question is a typical exciting problem on concealment and incontestability clause in life insurance. Let's take a look. The problem runs, Diego, a cancer survivor, filed an application for a life insurance policy with Garantia Insurance Company. He delivered this application and insurance premium to Gabriela, the officer of GIC in charge of approving life insurance policies. Gabriela then approved the application of Diego on June 1, 2020. On January 30, 2023, Diego died in a vehicular accident. When the heirs of Diego claimed the insurance proceeds, GIC denied the claim on the ground that Diego has concealed the fact of his illness. Moreover, Gabriela knew about the illness of Diego but also concealed it from GIC. Is the denial of the insurance claim by GIC proper? Now, as a general rule, remember in insurance, concealment essentially affects the utmost trust and confidence required for the component of consent. Pero may exception dyan in life insurance. Okay. And so let's take a look at the answer. No, Garantia Insurance denial of Diego's heirs claim is not proper. Garantia can no longer deny the insurance because the 2-year concealment period already lapsed on June 2 June 2022. Diego died in 30 January 2023 when his life insurance can no longer be cancelled. No? Kumbaga sa natapos na yung period of tawag dito yung contestability. Kasi the insurance contract started on January 30, 2023. So that by dito, nakalagay dito, the approval of the application was done on June 1, 2020. So if you count 2 years, 2021, 2022, kaya sinasabi rito, on June 2, 2022, no? Tapos na yung contestability period. So on June 2, incontestable na yung insurance coverage even if there was concealment. Namatay siya January 30, 2023. Lampas na. It is already outside of the contestable period. And so our section 48 of the insurance code says that after a policy of life insurance made payable on the death of the insured shall have been enforced during the lifetime of the insured for a period of 2 years from the date of its issuance or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or misrepresentation. This was also by way of a monumental decision by the Supreme Court decided in the case of Manila Bankers Life Insurance versus Crescencia P. Aban, a decision made in 2013. So that essentially covers the module on insurance, which is only 2 questions. So nakatapos na tayo ng corporation, banking, common carrier, insurance. We only have 2 remaining subject matters, and this is on intellectual property. There were 3 problems given. on intellectual property. And the first problem runs like this. It covers the issue of unfair competition, copyright, and patent. So let's start first with unfair competition. Uh, Balik ulit tayo sa taas. The unfair competition had something to do with brand name. And so problem number 12 says, Kagandahan Corporation or KC has been manufacturing medicated facial creams with the brand name Cutis since 2010. The facial creams are contained in pink, oval-shaped containers. However, KC did not secure a trademark registration for the brand name and the packaging. Later, upon discovering that there is no existing trademark registration in favor of KC, Big Honey Corporation manufactured its own facial creams using different ingredients and procedure but under the trademark Cutis, the same as what Casey was saying, and sold the facial creams in pink, oval-shaped containers. So, abig na naman doon. Similar to those sold by KC. However, the label of BC specifically indicates that it is manufactured by BC. Is BC liable for unfair competition? Discuss your answer. Our suggested answer is no. BC is not liable for unfair competition. This Cutis medicated facial cream is a product which uses ingredients and manufacturing procedure different from Kagandahan Corporation's KC. BC was not passing off or attempting to pass off upon the public KC's facial cream to deceive the public. While there is a similarity in the general appearance of the facial creams, BC's product is properly labeled as made by him. BC did not intend to deceive the public and defraud competitor KC. A decision that was made in Superior Commercial Enterprise versus Kunan Enterprise of 2010, and also the highly famous Suneca Pharmaceutical versus Natra Farm, also on the 2020 decision. So walang unfairness. Kahit pareho yung brand, kahit pareho yung tsura. Pero iba naman yung produkto eh. Iba naman ang produkto. And one is not being passed on as if sinasabi naman, ito produkto namin. BC kami, hindi kami KC. At meron kami sariling formula. So there is no what you call this unfairness there. Gusto bumalik doon, ayaw umalis. Natuwa siya rin sa Cutis brand. So balikan natin yung hindi na Cutis brand. Balikan natin yung copyright. Doon napakagandang problem. And it became a little complicated. No? Bantayan natin. Ganda-ganda nitong problem. Copyright. Okay. The problem runs like this. Template, deed of sale. Hindi pala ito. Pero tingnan natin, number 13 to. Attorney Matalas prepared the deed of sale which contains all the elements necessary to perfect the contract, particularly a statement of the agreement to transfer in an absolute manner the parcel of land that was specifically described as well as the price certain. Impressed by his own draft deed of sale, Attorney Matalas wants to use the deed that he prepared as a template and to secure a copyright registration for the same. Can Attorney Matalas secure a copyright registration for the template? Discuss your answer. Answer, no. Attorney Matalas cannot secure a copyright registration for his deed of sale template. The intellectual property listed those covered under the law. Matalas' deed of sale template is not among the list. And so we listed here copyrights included the following: literary and artist works. Wala dito yung deed of sale format. Yun, books and pamphlets, lectures, dramatic or dramatico-musical compositions, periodicals and newspapers, letters, musical compositions. Dito nga pala, may latest decision ng Supreme Court, no? Pagka merong composition, tapos meron kang restaurant, ginamit mo yon, no? For public performance, dapat magbayad ka ng royalty doon sa may-ari ng copyright. Kung hindi, may violation ng copyright law. Tapos derivative works, dramatization, translation, and so on. Collections of literary, scholarly, or artistic works, or compilations of data and other materials which are original by reason of selection or coordination or arrangement of their content. Kaya itong ating YouTube, technically, no, the way I understood it, the moment you get into this exercise, there is already an automatic application for copyright under the YouTube franchise. Okay. And so these were covered under Section 172 and 173, Chapter 2 and 3, Part 4 of Republic Act 8293, which is the intellectual property law. So hindi pwede yung template ni Matalas. Hindi masyado matalas yung kanyang template for registration. And so we're back to our modules on intellectual property. Dito pala yung sinasabi ko, no, nasa patent. Tingnan natin. Very interesting itong topic nito. Very good question for the bar exams. Napakagaling. Here, the problem reads, Julio, number 14 ito, secured a copyright registration for a drawing of a light box. Julio used the drawing for his advertisements, indicating the new internal electronic design features of the light box. 10 years after the registration of the copyright, Julian decided to manufacture and sell a light box with the same internal electrical design features as the light box drawing created by Julio. However, the physical appearance of the light box manufactured by Julian is different. Julio objected to the manufacture by Julian of the light box on the ground that he, Julio, is the inventor of the light box design. Is the objection of Julio valid? Discuss. Very interesting, no? Natin. So ito si Julio, siya yung nagrehistro noong copyright. Itong si Julian, siyang gumawa nung mismong talagang light box. No? So our suggested answer is no. Julio's objection is not valid. Julio has no patent for the light box, so he cannot establish to be its inventor. He has no basis of any patent infringement upon him. Hindi naman siya hindi naman siya nagrehistro na yung light box. Siya inventor. So he doesn't have a patent for that. Ang nirehistro lang niya yung drawing, no, na ipinasok niya as a copyright for purposes of showing what this box is all about. Okay. The Patent Office undertakes an exhaustive examination when a patent is issued in rewarding a useful invention to guard the rights and welfare of the community. Copyrights are granted upon creation with no scrutiny which an invention undergoes prior to the issuance of patent. So yung patent, detailed ang analysis na may kabutihan talaga yung inimbento. Yung copyright, applyan mo lang yun. In effect, yung brand name no, yung trademark mo. Bibigay sa iyo kaagad yun. Hindi chine-check kung yung produkto that is using your brand name or trademark is a valid invention. Hindi na niliso, yun ang pangalan. And so, Julio cannot exclude others from the manufacture, sale, or commercial use of the light boxes on the sole basis of his copyright certificate over the technical drawings. This was decided in the case of Perlandine versus Schumacher, a 2003 decision. Ganda, no? Napaka-pinong-pino, napaka-distinguished. And so that finishes our intellectual property coverage in the 2023 bar examination. We are now winding up to go into the special topic of insurance, of income, of taxation. Okay. Tingnan na natin, taxation. In taxation, there were 5 problems that were given. And they are fair questions in taxation na hindi naman basta binigay lang para masabing may problem sa taxation. Okay, so those are the problems. Tax enactment, legislative power, tax return failure to file, income tax deduction, value-added tax on professionals, and the real property tax exemption. Tingnan muna natin yung tax enactment, legislative power. Ayusin natin itong mga ano natin. Dito tayo mga kaibigan. No? So continuing now, here, the sovereign power of taxation being vested in the legislature. Problem. Upon seeing the global popularity of Korean culture, the President of the Philippines wanted to export Philippine culture as well. Thus, he met with both the Secretary of Tourism and the chairperson of the National Commission for Culture and the Arts to come up with a plan to make Philippine culture as the next big thing. After a series of meetings with industry stakeholders and with a resolution of support from Congress, the President issued a presidential proclamation granting tax exemptions to members of the Philippine entertainment and culinary industries who export 70% of their products and services. The proclamation also grants additional tax incentives such as an income tax holiday to artists, directors, chefs, studios, both TV and music, and authors who gain international acclaim. Is the proclamation constitutional? Explain your answer. This is very interesting. Kasi nasanay tayo. Bongbong Marcos yan. Anak yan ni Ferdinand Marcos na mahiling mag-issue ng presidential proclamation. Okay. Pero hindi naman sinabi nito si Bongbong itong presidente. So here, the answer is no. The presidential proclamation is unconstitutional. The Constitution granted Congress the sovereign authority to enact tax laws. Hence, tax exemptions must likewise be exercised through the legislature. And the Constitution says all revenue or tariff bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. And no law granting any tax exemption shall be passed without the concurrence or a majority of all the members of Congress. Masyadong malinaw na hindi po pwede yung presidential proclamation of tax exemption can violate this specific section 28 of Article 6 of the Constitution. So, presidential proclamation is unconstitutional. So, the next topic in taxation under is the tax return on failure to file. Ito, very interesting argument ito. And ito yung argument ng mga pilosopo, no? And minsan mahirap intindihin, pilosopo eh. Willful neglect to file. Sabi niya, Pedro ran a gambling den in the basement of a bar called Apolaki in Intramuros, Manila. His gambling operations consisted of a pastime from the late 70s called ratting, where barrels of rats would be released on a fenced-off area for a cat to eat. Bettors would then wager on how many rats would be killed by the cat in a certain given time. As can be easily gathered, this is highly illegal. The apparent illegality did not stop Pedro from making millions of pesos from on-site and online bettors. Needless to say, Pedro did not file an income tax return to report his income. Based on the complaint of the Commissioner of Internal Revenue, the Department of Justice filed an information against Pedro for failure to file an income tax return under Section 255 of the National Internal Revenue Code. In his defense, Pedro argued that the profits from the gambling operations are not income in the first place because declaring such would violate his right against self-incrimination. So, ganda. Hence, he is not required to file an income tax return is the argument of Pedro Tenable. Explain. Napakaganda. Hindi ako dapat mag-file ng income tax return kasi I would be in effect incriminating myself that I have an income and a tax and I have not paid. Incriminating. So sagot natin, no, Pedro's argument is not tenable. The law requires Pedro, a taxpayer, to file his income tax return as a duty and an obligation. Hoy Pedro, walang self-incrimination yan. You are being ordered by the exercise of the sovereign power of taxation. Hindi rin power yan na state. Sinuutusan ka mag-file ng income tax at magbayad ng tax. Neglect or failure to file your tax return is punishable with a fine of not less than 10,000 pesos and imprisonment of not less than 1 year but not more than 10 years. For willful neglect to file the return within the period prescribed under the tax code or by rules and regulations, the penalty is 50% of the tax or of the deficiency tax in case any payment has been made on the basis of such return before the discovery of the falsity or fraud. This is under Section 255 of the National Internal Revenue Code. This is an additional side comment. Yung 50%, for example, if this particular person now files an appeal, let's say, nag-file siya ng motion for investigation or motion for investigation or reconsideration with the Bureau of Internal Revenue. Siyempre, di-deny na Internal Revenue. So, magpa-file siya ng appeal before the Court of Tax Appeals. Now, there is a school of thought that says that the penalty, no, and whatever interest that has to be done should be computed on the basis of the amount that the Court of Tax Appeals should grant. Tama naman. Pag nag-compute ka ng 50% plus yung 12% interest mo, dapat simulan mong computin mo yan on the basis of either, well, kung itinaasan, okay. Pero bihira naman yun. So, kung binabaan, no, it will be the lower amount granted by the Court of Tax Appeals. That will be the basis of the 50%. Walang question yun. Ang question, kailan dapat bayaran yung penalty and interest? The Supreme Court has decided, ang punente si Justice Leonin, na dapat daw bayaran mo yung penalty from the time na in-assess ka ng BIR, hindi from the time na in-approve ng CTA yung lower case. So, pag in-assess ka ng BIR, you pay immediately, no? And subject to, of course, you are required to pay the tax after the CTA decision. Pero yung computation ng penalty at interest magsisimula hindi sa approval ng CTA or Supreme Court, kung hindi from the time na in-assess ka ng BIR. So it may be a lower tax, but the penalty and the interest would still be computed to include the period na from the time na in-assess ka up to the time na na-approve yung iyong appeal. That's a later development na hindi kasama dito, but it is somehow related. Sama na natin. The third question in taxation is income tax deductions. Ito, napakaganda. Under the principle of what are allowable deductions in income taxation. The problem reads, income taxation deductions expenses. Marites is the Chief Executive Officer and sole shareholder of Chismis Ngayon, OPC. a one-person corporation that runs a popular blog about showbiz news and juicy gossip. From March to April 2023, Marites asked her daughter Laya to work as an intern in the corporation and help around the press room. Her main duties were brewing coffee for the editorial staff and printing out hard copies of TNO blog posts for filing purposes. Laya did a decent but not excellent job as an intern in her 2 month stint with TNO, except for the one time when she added 2 packets of sugar to the cup of coffee of a diabetic senior officer. Proud of the performance of Laya, Marites issued a TNO resolution granting a 2 million bonus to Laya. Laya used the 2 million bonus to buy a new car. Can TNO claim the 2 million bonus as a deduction? Explain your answer. Suggested answer is no. TNO cannot claim as a deduction the exorbitant 2 million bonus. The requisites for the deductibility of tax-deductible expenses include ordinary and necessary expenses, paid or incurred during the taxable year, paid or incurred in carrying on the trade or business of the taxpayer, and supported by receipts, records, or other pertinent papers. Dito umiikot ang criticality whether or not it is deductible. Law's duties did not appear to be ordinary and necessary. Isipin mo naman, nagtitimpla lang ng kape, nagpiprint ng kopya. Yung ba mamamatay ka kung in business mo kung wala yun. No? For TNO blog on showbiz news and juicy gossip, said business will proceed even in the absence of Law's duties. So, that will not be a tax-deductible expense of exorbitant 2 million. Second to the last question, in the 2023 bar examination on Mercantile Law and Taxation, value-added tax on professionals. Internal revenue and the value-added tax on professionals. The problem reads, Ikapati Corporation IC is a value-added tax registered corporation that sells various kinds of instant noodles. It is recognized as the industry leader, especially after its spicy bulalo flavor gained immense popularity in December 2021. The success of IC has been attributed to its tax lawyer, Attorney Mahal, who helps IC understand the National Internal Revenue Code to its advantage. To show its appreciation, IC sent Attorney Mahal 1,000 boxes of spicy bulalo instant noodles. Is the transfer of 1,000 boxes of instant noodles to Attorney Mahal subject to VAT? Explain. Answer, yes. Attorney Mahal's instant noodles is subject to value-added tax. Services of professional practitioners are subject to VAT when gross professional fees exceed 1.5 million for a 12-month period and subject to 3% percentage tax if gross professional fees total 1,500,000 and below for a 12-month period. Attorney Mahal's attorney's fees is subject to his own output VAT. Meron siya output VAT na magiging input VAT ni Ikapati. Ikapati's transfer of 1,000 boxes of instant noodles will be subject to output VAT naman of Ikapati. Attorney Mahal remits to the BIR his net output VAT, computed as his output VAT on his professional services minus his input VAT on the noodles received. Ganun lang kasimple. And the last problem on taxation under mercantile law is a standard problem in real property tax exemption. Paulit-ulit to binibigay year after year, and therefore no lawyer deserves to pass the bar if you were to be a lawyer unless you know this. Under the local tax code and real property tax. Again, real property now is a tax that belongs to, of course, the province. That belongs to the municipality or city. It's no longer part of the province. Okay? So this is problem number 20, the last problem in the bar. It says, Quezon City assessed the Light Rail Transit Authority of real property taxes on its properties consisting of lands, buildings, machineries, and terminal stations. Despite repeated demands from Quezon City, LRTA failed to pay its outstanding obligations, prompting the city to issue a notice of delinquency with warrants of levy. LRTA questioned the assessments of Quezon City, claiming that it is exempt from real property tax. LRTA argues that it is operating a light rail transit system for the Philippines, which is the true owner of the subject and real properties. Is LRTA exempt from real property tax? Explain briefly. Answer: yes, LRTA is not exempt from real property tax. Unlike the public roads which are used by everyone, the LRT is accessible only to those who pay the required fare. It does not exist solely for public service. Its LRT carriageways and terminal stations are not exclusively for public use. While being a public utility, it is profit earning rather, and earns money from the carriageways and terminal stations. Real property owned by the Republic of the Philippines or any of its political subdivisions and any government-owned or controlled corporation so exempt by its charter, provided, however, that this exemption shall not apply to real property of the above named entities who are for its beneficial use of which it has been granted, for consideration or otherwise, is a taxable person. In bottom line, even if the property is owned by the Philippines, like ito, ang classic example dito, are the mining rights given to mining companies. Celebrated case na ito, when the mining companies were being charged real property tax. They said, well, the property you're taxing is government property. And so you tax the government, not us. We are only using it. The decision of the Supreme Court says that, well, that's government property. What's being taxed for real property is the beneficial use of that particular property. So that property is paying real property tax arising from the beneficial use of that property, and the beneficiary becomes liable for the tax. So mining companies you pay. Ganon din ang principle sa LRT. They're supposed to be liable. My dear friends, that is the component of taxation in the 2023 Mercantile Law and Taxation Barracks House. And if we are to go back to our main coverage is this one. Siguro pwede na nating ilagay dito sa gitna ito. Dahil natapos na natin. And so you have seen the coverage of the 2023 bar examination in Mercantile Law. I do not consider the Mercantile Law bar exam as easy, neither is it impossible. But those who will pass this examination will definitely be those who have studied well and know the law too well. Babalik tayo rin sa and I think we don't have to do that anymore. Tignan natin kung saan tayo makakarating dito, but I'd like to finally plus to you. Ito na yung mga sunod-sunod na problem natin that we took up according to the area of specialization that they belong to. No? And so, I am closing this particular sharing session on Mercantile Law, and I hope for those who will be going to this, it will allow you additional knowledge, and for those who took the bar examination, it will allow you to see what are the possible sources of your passing the bar with this particular questions and suggested answers. Mga kaibigan, this is very memorable to me in the sense that I am resuming this, and I intend to resume many of my discussion. Maraming pa na-interrupt lang. And dahil yung iba sa inyo, nagbibiro sa akin, din, kilala ka na namin. So, with or without your qualifications, we already know you. But for those who are watching our slide for the first time, I still resurrected the usual thing that we flash on my background in academics, corporate management, and just for sentimental purposes, wala na, sentimental purposes, let me just tell you that I have always wanted to be a lawyer since I was a young person. I was very good in debate. I was a good speaker, outstanding speeches in high school, and orator, declaimer even in college. And my capacity to speak also allowed me to get my high honors in college and also the MBA program in the college. When I went back to law school, I was 40 years old. At 35, the Heart Center, headed by its head of the medical staff, Dr. Abundo, diagnosed that I have a heart block, particularly in the aorta area. Yung entry level ng dugo papunta sa puso. And so para kang nakasakal yung puso mo. And so to my mind, at 35 I said, siguro 5 taon nang matatagal ko sa buhay na ito. And, my children are still in school, may mga utang pa kami. Ganda lang ang buhay. So I said, okay lang. And I could not be operated on for bypass dahil masyado raw bata. Pag binuksan daw yun, masyadong mahal. After siguro mga 3-4 years din, 5 years, barado na naman. So, magsugal na lang daw ako na, yun, number 1, medication, bawas yung kain, so bawas ang weight, exercise. But the most important thing is stress. Corporate world ako, pag di pansweldo ng tao, pag walang pera yung korporasyon, kahit yung presidente, wala na siyang problema doon. Problema ko as finance officer. So, and there were companies that ako mismo nagsarado ng kumpanya dahil I was the last to leave as closing the company. So yun, I was the youngest in the management group of Furadan, Asia Pacific Agricultural Development Corporation. Ako lang yung hindi pumasa sa executive checkup. So, I was sad, pero sabi nga nung doktora ko, after 2 years, pumasa ako sa stress test. Paano ko raw nagawa kayo? May bara ako. So, apparently, things were improving. And so, I found pa a job. I was jobless at a certain point. I found a job na yung sweldo ko malaki, pero yung trabaho ko mas mababa. Halos supervisor lang. Kayang-kaya. So, after 2 years na halos minamani ko, binigyan na sa akin pinakamahirap na trabaho. Financial budgeting, forecasting, lahat yun binigay sa akin. Nadali pa din because I came from a higher level as vice president. Nahawak ko lahat. Accounting, treasury systems, binigay lang sa akin nung una, accounting. Tapos later on, binigay sa akin financial planning and budgets. Humingi lang ako ng computer because I was in an early stage of my career. Magaling na ako sa computer. Kaya nga ito, akong gumagawa nito. So, when I felt na after 2 years, medyo okay na ako, nagpaalam ako nun sa aking cardiologist, Dr. Abundo na, ma'am, pwede po ba magpaalam na mag-aaral ulit ako? Sabi niya, anong pag-aaralan mo? Sabi ko, law. And she looked at me and stared with me with a sharp pair of 2 eyes and said, alam mo, sabi niya, are you crazy? Alam mo yung sakit mong yan? One click ka lang, yari ka na. Pag-aaral ka pa ng law, nagtatrabaho ka, may pamilya ka, nagtuturo ka pa sa MBA with all the stress. Sabihin mo sa akin, mag-aaral ka ng law. Para sinabi mo na gusto mo nang mamatay. I promise you, sabi niya, it's a very stressful thing, hindi lang pagka-aral sa law. Pag naging abogado ka, stressful lalo yan, sabi niya. And she was speaking with authority because yung husband niya at yung anak niya, parehong abogado. So she's not theorizing. Sabi niya, alam mo, Joe, when my husband was reviewing for the bar, kakakasal namin, nakita kong hirap niyang pag-aaral. Nakita kong hirap nila up to na abogado. Sabi mo sa akin, mag-aaral ka ng law. O, tapos ganyan, meron kang bum heart. So I promise you, sabi niya, you will die. You cannot finish your 4-year course or 5-year course in law. You will die. Bakit ba gusto maging abogado? Gusto ko, pag namatay ako sa lapid ako nakalagay attorney. Tapos ngumiti na lang ako. Iling-iling siya. Sabi siguro, sira ang ulo nito. And you know, that was how many years ago. So, yun, pasok ko sa College of Law. Ako pinakamatanda. Nung nag-a-apply ako para kakamuha ng law, sabi sa akin din si Ledonio Chongso ng UE, nag-professor ko. Sabi nga niya, estudyante kita 25 years ago, matatinig ang utak mo, nandiyan pa ba? Kaya mo pa ba? And so, he tolerated me to enter law school every semester. Nandito ka pa. Kasi I was a very senior finance officer. And so, normally di tumatagal yung mga ganun. Yung torture pa sa klase, tatawagin ka, i-insultuhin ka, bibigyan ka ng 5. Ang pagtitiis, ganun na lang. Pero marami akong mga branch sa fraternity na nag-drop out din sa law school kasi nga third year na, masyado napapaya ng mga restriction. Ako, I have my own share. Pero alam ko yun kaya I never tried to show off in law school. Isa ka sa pinakatahimik na sana paupo ako. Absent yung professor. Andun ako, hindi ako maalis sa klase. That's his lesson on property. Pag yung professor kwento lang ng kwento, sige, pag tumawala, tatawa ako. Pagka natapos yung buong period, puro kwento ng kabulastugan, titising ko lang. Pero nag-aaral ako. I was ready. Kasi hindi ko naman siya kasama with his dirty jokes. Pag kumuha ako sa bar, nag-iisa lang ako sa bar. And it's even sad. Third year ako, namatay ang tatay ko. Hindi niya naabutan na graduate ako ng law. I finished law. My mother was there. Nagre-review ko sa bar. Pinasok ng magnanakaw. Pinatay. Yun. Victim of robbery with homicide. Pinapospon ng mga professor ko yung pagkuha ko ng bar ng 1992. So I took it in 1992. Siyempre, nag-ambisyon naman ako mag-top. Ba't pa ako mag-aaral ng law? Matanda kung hindi magtatap. Hindi naman tayo sinuwerte. Ganun talaga. Marami. I know the reason why. I took some reason my answers. But okay lang. But to be a lawyer at the age of 47, I took my oath. 47 years old ako. And after a few years, nalusutan ko ng 10 years and so on. Ayun. Nominated ako 2 beses. Hindi naman ako nominate. Talagang nag-apply ako. Oo. 2006 yata. In 2012. Sabay ko si Leonen doon sa pati sa IQ exam, psychological exam sa GBC. Alam ko naman, siya i-appoint ni Noynoy. Wala naman akong connection kay Noynoy. Basta ako umabot sa Judicial and Bar Council and I participated in the public interview. And, I'm never ashamed of my answer and my performance. Alam ko, hindi ako kukunin. Wala akong kapit. Totally, wala akong kapit. Sa sinugal ko lang na ito ko, matanda na ako maging abogado. In fact, during the second interview, si Justice Angelina Sandoval Gutierrez, acting chairman, sabi sa akin, Din Bisquera, bakit ngayon ka lang nag-a-apply? Parang sinabi, kung nag-apply ka noon, matagal ka ng Justice na Supreme Court. Sabi ko, ma'am, naging abogado ko 47, so 10 years 57. Ever since ka ako nag-a-apply na ako lahat ng klase ng posisyon. Hindi ko lang masabi, pati clerk of court siguro kung pwede. Pero wala, I've never been given a chance to be in the judiciary. Mabuti naman ako, you're giving me the chance to just answer what what I have to present to become associate justice. So, ganun talaga ang buhay. No? Pero sa akin, tama na yun. Na umabot ka sa Judicial and Bar Council, kinonsider ka, seriously. May mga bumulong sa akin, sana matsabahan ko raw. Pero matino akong tao, matino akong magaling na abogado. Okay na yun. Okay na yun. So now, if I get married, not pa din panaginip ko, sa lapid ako may attorney na. Pero nagkamali yung UM in-appoint pa ako na din, so magkakaroon ng din attorney. So mga kaibigan, maraming salamat. I will have 2 more uploads. Tapos na rin po, nag-shutdown lang yung PLDT Wi-Fi about almost 2 weeks ago. So this should have been uploaded already. Tapos ang susunod na, yung dalawang very exciting subject. Matagal ko na natapos din yung criminal law. It's very exciting. Magaganda yung mga sagot ko doon. And then finally, natapos ko 2 days ago, no? Procedural law, remedial law. Maganda rin. Pero hindi ganun kahirap ang remedial law. Mas mahirap ang criminal law. At medyo mas mahirap pa ng konti itong mercantile law. So with this, I'd like to thank you very much, mga kaibigan ko. And I will see you in the next module. Pakichismis nyo lang po sa mga kaibigan nyo. Sana manood. Tsaka, yun yung nakalagay na subscribe. Pakisubscribe lang po. Magtatatlong taon na akong nag-upload dito. Hindi pa ako nababayaran ng YouTube. Ewan ko, may statics yata sa payment sa akin. Sinasabi, ganun na raw yung mga check na aubis ako. Kailangan daw padala sa akin. Kailangan daw po. So please continue to subscribe para naman sakaling may pambili ng papel at pambili ng ink si Din Bisquera kung maubusan. Thank you very much and I love you all. I love doing this job and I'm proud of all of you who love the law like me. Maraming pong salamat and I'd like to see you in the next subsequent slides.